Hello everyone and welcome to today's Mondac webinar in association with Immigration Solutions Lawyers, who will be discussing the complexities surrounding red notices and character assessments in the visa application process. And my apologies for the delayed start today. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Anne O'Donoghue is an accredited immigration law specialist with over 30 years of experience. She is the director and principal lawyer of Immigration Solutions Lawyers and is acknowledged as one of Australia's leading immigration law specialists and has a special interest in modern slavery and human rights and professional ethics. In 1998, Anne received her specialist accreditation as an immigration lawyer from the New South Wales Law Society. She's been instrumental in developing the field of immigration law in New South Wales and was the founding Vice President of the Migration Law Committee of the Law Council of Australia. Ben Keefe is a leading barrister specialising in cross-border and international cases. He deals with all aspects of extradition, human rights, mutual legal assistance, Interpol, financial crime and international law, including sanctions. He represents governments, political and military leaders, high net worth individuals, human rights defenders and business leaders in the most sensitive cases. He has extensive experience of appellate proceedings before the administrative and divisional courts, civil and criminal divisions of the Court of Appeal and the Supreme Court, as well as applications and appeals to the European Court of Human Rights and United Nations. Before we begin today's webinar, a quick housekeeping item. You can submit questions to the panel by typing them into the questions pane of a toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible during our Q&A session at the end of today's webinar. It's now my pleasure to hand you over to Anne and Ben to begin. Thank you.
Thank you so much, Ben. It's a pleasure to be here this evening and in the morning for our other observers. I'm going to talk about what are character concerns, particularly in relation to the Australian context. Character concerns emerge when an individual's past behaviour or actions cast doubt on their suitability to remain or enter the country. Addressing these concerns really are of paramount importance, and we do have legislation that covers these concerns, mainly Section 501 of the Migration Act, and we've just recently had a new Direction 110, which had, its previous predecessor was Direction 99, which had a lot of political interest recently. Now, under Section 501 of the Migration Act, the Minister of Immigration and Citizenship basically may cancel a visa on character grounds. The Minister may cancel where he or she reasonably suspects that the person does not pass the character test, and the character test is looked at. Section 501 of the Migration Act provides guidance in relation to the character test. The Minister may cancel a person's visa if the person does not pass the character test. A person does not pass the character test if they have what they call a substantial criminal record, which is basically any period of detention, or if they've been found to be a member of a group or organisation involved in criminal conduct. The Minister must consider a wide range of factors when deciding whether to cancel a person's visa, including their age, the length of time they've been in Australia, their ties to Australia, and their immigration history, their employment, education, and physical and mental health and well-being. The Minister also has a personal ability to cancel a person's visa if they do not pass the character test, if the Minister reasonably suspects that the person has been involved in criminal conduct, represents a danger to the Australian community, or is otherwise not a good character. And that's Section 501(3)(a), which is a personal power of the Minister, where there are no administrative appeal rights, and the High Court, and it also brings in the notion of national interest, which has been defined by the High Court. A person whose visa has been cancelled under 501 may apply for revocation or cancellation, but not if it's a personal decision of the Minister. If you're applying for a visa application and you have character concerns, you'll be typically have your visa assessed by the Department of Home Affairs, and then it's referred to the special visa character consideration unit known as VACU. Recent processing times with VACU have been quite delayed, and until VACU makes a decision on that visa cancellation, nothing will happen, and it will remain in VACU until they have made that decision. We've now got a new Direction 110, which I'll speak of later down the track. Now, if the department intends on refusing your visa application, they will issue with a notice of intention to refuse the visa, and you do have administrative rights to respond to that. Now, the next issue that I really wanted to talk about was the issuing of the notice of intention to cancel, which is an administrative process they go through. These notices are part of ensuring natural justice is exercised. However, the minister, if it personally cancels the visa under 5013 that I mentioned earlier, natural justice does not apply and instead makes a decision ultimately in line with the national interest. It will revert back to the notion of national interest shortly. Now, if a person receives the notice of visa cancellation, the applicant must address considerations as to why applicants' visas should not be cancelled and their visa should be reinstated. Now, these new considerations are detailed in the new Direction 110, which I will speak of in length later on. I'll just see how I'm going for time. A ministerial direction under Australian law is a formal instruction issued by the government minister, often the Minister for Immigration, to provide guidance on how certain discretionary powers should be exercised under the law. These directions help ensure that the decisions are made consistently, transparently, in alignment with government policies. Direction 110 states that the protection of the Australian community from criminal or other serious conduct is generally to be given a greater weight than any other primary consideration. This is paired with the new language in Direction 110 that states that the safety of Australian community is the highest priority of the Australian government. Now, there's a big difference between the previous direction of 99, which did result in the release of quite a few people with character concerns. And this direction has been revoked and the new direction has come into place. That sort of gives you an overall picture of the Australian position, but character is an essential issue. All visas in Australia are subject to health and character criteria, and it's a very important issue to deal with. It's now more difficult with the revised ministerial direction. You've got Section 501 and you've got the ministerial direction of 110, and you've also got the High Court decision and definition of what is in the national interest. So that's just a brief overview. I think we're now going to go to Ben. So he's going to give us an overview of the UK position.
Thanks, Anne. Well, what I thought I'd do very briefly is just outline to you a few aspects of the UK character provisions, but also then go through really how Interpol interacts with those issues. Good character in the UK is slightly more amorphous than the definitions given in Australia. A person has to be of good character to be granted a visa or to be granted citizenship. But what good character means isn't always entirely clear. In particular, somebody has to not have been convicted of a criminal offence, a serious criminal offence, or any of the international criminal offences, war crimes, genocide, those sorts of things. But in relation to criminality, we have various different tiers of criminality. So if you've received a sentence of at least 12 months in the UK or overseas, then you're not considered to be not of good character. And and that can be a set of consecutive sentences of smaller length, or if you're a persistent offender, or whether all your offences are called serious harm, or there's issues around sexual offences recorded in the UK police registers. The complications really come, sort of my specialism is where there are there's talk of prosecutions overseas. So where you are accused of a criminal offence in either or usually your state of origin, but sometimes in a third state, and as a result, a red notice has been issued. And in those circumstances, the UK authorities will sometimes use that red notice as a reason to doubt your good character. Now, in Australia, I think the system is much more rigid in that I've seen that those who are subject to red notices are effectively barred from good character and have to prove that the red notice is illicit or illegally obtained by the requesting state. And I think we're going to come back and have a discussion about, particularly in Australia, in relation to the issues around China and the abuse of Interpol. But I thought I'd just give you a very brief overview of the issues surrounding Interpol. So Interpol is the International Criminal Police Organization, has 195 member states. In fact, they've just elected a new, or about to recommend a new Secretary General, who's a Brazilian, very senior Brazilian police officer, and he will be, I understand, become the Secretary General in October of this year, which will be confirmed in the Glasgow General Meeting. Interpol is an intelligence sharing organisation. It's not a police force. It doesn't have agents on the ground. Its job is to share information between member states. And it's shared through a number of different mechanisms. The most famous of those is the Red Notice. And the Red Notice is when a national central bureau, which is designated in each country, so that the central international cooperation section of the police force in a particular country makes a request either to Interpol to put a red notice on, or to a particular country directly to search and find an individual. So where is that individual residing? If they cross a border, we want to know that, because then we will use that information in order to issue an extradition request and hopefully detain him or her. The issue comes is that red notices are often abused, particularly by states without the rule of law. And also, Interpol red notices are treated quite differently by different jurisdictions. So, by way of example, the United Kingdom will not generally arrest somebody entering the United Kingdom on a red notice unless that red notice is from one of the members of the Five Eyes countries. But if, for instance, there's a red notice from Ukraine or Russia, you can enter the UK, you might get stopped at the border, a flash will go back to Interpol Kiev, and then Interpol Kiev will have to decide whether they're going to try and extradite somebody from the United Kingdom. Other countries treat the red notice as an arrest warrant. So France, for instance, will arrest somebody on a red notice and detain them, what is considered their detention, pending provision of a full extradition request by whichever country they have a treaty with. And there are real problems. I mean, France has a treaty with China, and although they've not extradited anybody there, they have detained a number of people while pending extradition proceedings there. And this interaction becomes more difficult, particularly when you are dealing with asylum cases, as well as visa cases, where individuals are subject to a prosecution potentially. It might be a political prosecution, and then the particular state, often one who uses transnational repression, will use a red notice to target somebody abroad, because the targeting of somebody with a red notice has a myriad number of effects. It's not just a precursor to extradition. It can stop your banking. You'll often be debanked by the existence of the red notice. Often the publicity surrounding the red notice will cause you to have other issues. You might become a politically exposed person. And when you apply for visas, nationality, or asylum, it can, particularly in the United Kingdom, can lead to the serious questions being asked about whether or not the person applying is a criminal. But Interpol are very clear that a red notice is not an extradition request. It is simply a marker to try and find somebody. And Interpol are also very clear that they do not get involved in extradition requests. Their job is solely to find the individual. And when they found the individual, then it is left to the domestic criminal or extradition process to decide whether or not somebody is going to be extradited. But I have seen in some Australian cases that the Australian authorities consider red notice to be much more serious and will use that as the sole reason to say that you don't have good character without any further analysis. We're about to go through a change of government potentially, but very recently Tom Tugendhat, the Securities Minister, said in a podcast interview for Sky News that the UK tend to ignore requests from China and Russia. Now, I'm not sure that's an official policy, and I'm not sure he should have said that, but that's what he did say. That's in the podcast, and that correlates with what the UK legal community sees, because prior to the last 2 or 3 years, Russia was a fairly active extradition partner. Now, we only extradited one individual to Russia in all that time because all of the extradition requests from Russia, turned out to be politically motivated. But we still engaged in the process. There were lots of extradition hearings. There was lots of work for lawyers. And since, in the last few years, basically since bits since Litvinenko, but then more since the Salisbury attacks, there hasn't been any that we know of properly. Very few Russian requests that have been certified. And there's a cadre of autocratic states who use Interpol to search for individuals. Some of them are criminals. Some of them are human rights defenders. Often they're opposition politicians, and they are, I would say, the usual suspects, but they include Russia as being one of the main abusers of Interpol. They include China, and I'll come back to China in a bit, the United Arab Emirates, Qatar, Bahrain. I know that a lot of South American states have been accused of misusing Interpol, particularly Ecuador. But for geographical reasons, I don't tend to deal with the South American cases. I tend to deal with former CIS states and Chinese cases. And so when you see a red notice, it doesn't actually mean that your client is guilty of an offence, and it doesn't always mean that they are in fact even accused. Sometimes the presence of a red notice can be obtained in different states through bribery, corruption, leverage, and depending on the state that is in, depends on how likely the red notice is to be genuine. And one of the main abusers of Interpol is in fact Turkey. It has gone after thousands and thousands and thousands of individuals who are purported to be Gulenists or anti the current regime, and there's been huge problems with extradition and red notices from Turkey. So, I mean, those are just a few of the states. I mean, there's problems with Rwanda, Nigeria, Zambia, all manner of places in which the rule of law doesn't function effectively. And the real problem with Interpol is that it's a collaborative process through all 195 member states, who all of whom have very, very different levels of rule of law and levels of human rights protection. But Interpol treats everybody the same, when perhaps, or at least in my opinion, they should try and treat them slightly differently. And so when you have one of these, when you have a red notice or a diffusion, which is a direct communication, then you need to look in some detail at what it actually means and whether it is in fact a genuine criminal allegation against a client, and therefore whether it in fact does impact upon somebody's character and then upon somebody's visa, or whether in fact there is real reason to doubt that the request, the red notice, is a genuine one. I mean, that's a sort of whistle-stop tour, Anne. I thought I'd just do a little summary. Um, but I mean, how important is? I mean, the real issues I've seen in Australia are the way that China used red notice to target former Chinese nationals in Australia and cause them real problems.
Well, I do think that Australia places far too much emphasis on the red notices. I think the famous case was the Egyptian case in, I think, 2017, which took quite some time, where they actually Interpol reviewed their review of the situation of the charges that took place in Egypt and the judicial process that went through. Um, and the Interpol review was considered a critical step towards clearing the applicant and resolving his prolonged detention in Australia. Now, of course, no, that wouldn't happen, but that was back in 2017. But we've got a new direction, 110 now, which I think with the focus on a strong emphasis on national interest and community safety, we're going to see the red notice situation become even more relevant and prevalent in relation to perhaps a visa cancellation or a refusal. And um, I think this is something that we need to look at, because the previous direction 99 brought up family and ties in Australia to a primary consideration. Now it's still a consideration, but it's been watered down. And the primary consideration, of course, is national interest and community safety. And this is the current situation um, that we're dealing with. And you can be dealing still with relatively low risk individuals with an offence that may have taken place, um, say, 15 years ago, and no reoffences, but you're still grappling with 501 and um, 110. I noticed that, like, if you're looking at a visitor's visa in the UK, and if you apply for a stay of more than 6 months, I mean, there's quite a bit of flexibility there. If, say, a 12-month period has happened and there's been no reoffences, in Australia, we don't have anything like that. We have a situation that if you've got a character concern, it's got to be disclosed. You may not have a substantial criminal record, which is usually 12 months, but then you could have a sort of a pattern of conduct. We had a particular a case of a New Zealand citizen who, I think it was about 15 years ago, and Diane worked on that particular case, and he was considered a behavioural concern because Australia and New Zealand share information. It was a fraudulent case, but his father was diagnosed with cancer. He thought he needed the money. He paid the money back, I think, within like 7 days, but this was still on his record, and he did get a conviction which was reduced to a custodial sentence in New Zealand to sort of like, I think, 11 months. Now, we did successfully apply for a visitor's visa, and there's a discretion, bit of a ministerial discretion, but the next step we had to consider was, well, he'd like to have freedom of access to coming to Australia and applying for a 444 visa, which is an automatic visa we give to New Zealand citizens. But hence, in the detail lay the difficulty. And I might just turn to Diane, if you could explain that we did not see any discretion there at all in the 444 visa.
Yes, that's right. So I think there is different layers to how character is assessed in Australia. There are visa subclasses and citizenship, for that matter, also, where consideration is given to an array of factors that mitigate criminal convictions or criminal history for applicants. But we see that there is inconsistencies that lie within those layers, where for our client, for example, who is a New Zealand citizen and would otherwise have been offered the opportunity to get a subclass 444, which is granted automatically upon arrival. He essentially is excluded from that right because of his previous criminal convictions, despite the mitigation that he was able to offer, albeit the fact that it was over nearly 2 decades ago. But I think that we see, especially in comparison to the UK, there's a difference in the amount of discretion that's provided and leniency that's provided for people who do have character concerns, despite the circumstances that they find themselves in.
I mean, what
Yes, we've
fascinates me
actually
about
thought it was just
Australia, sorry,
joking.
I mean, what fascinates me about Australia is the policy fluctuates from what I can see quite quickly. In that, I
Definitely.
mean, I dealt with a South Korean case a couple of years ago, in which one of my clients was accused of being a Deutsche Bank trader who dropped a percentage off the COPS index. He was arrested in Indonesia, he ended in the UK, and he was discharged in the United Kingdom in relation to political motivation in his case. But he had co-defendants who are all Deutsche Bank employees, and they were investigated by the Hong Kong Stock Exchange and regulators, and were found in the days when the Hong Kong regulators were genuine independent, and were found to be to have made some regulatory breaches, but not to have committed any criminal offences. And his co-defendants were Australian nationals, and they were in Australia, and we know that extradition requests came from South Korea, and the Australians effectively ignored them. Whereas for China, it seems to be, although I don't think that there isn't an extradition treaty from Australia to China, is there? I don't. Am I wrong about that? But
No,
no,
I
there
don't
is.
think
There is an.
there is.
I don't think there is. But
Mm.
the Chinese use Interpol in a very different way to everybody else, in that their modus operandi is they don't really care about using the red notice to extradite anybody or even to prosecute somebody. They just want to find somebody. And so they use the red notice to find somebody, and then when they found them, the Chinese have well over 100 police stations in foreign countries in which they station police officers, foreign police officers, Secret Service operatives, etc. And they will go round to the house of the person who they have found, and they will say to them, "Please come back to Beijing. We found you." And then they will say, "If you don't come back to Beijing, we have your grandmother or your aunt or your nephew or your son, and we're going to take them down to the police station, and we're going to detain them while we question them for weeks. And they're going to come back every week until you agree voluntarily to return to China and face the allegations." And they've hailed it. I mean, it's not a secret. They've said this is their aim. They've lauded the fact that many people have returned in quotation marks voluntarily, whilst using effectively illegal pressure. And what people probably don't realise is that the Chinese legal system doesn't really exist as we think of it as a proper legal system. I mean, the conviction rate is 99.97%. So I'm not sure you can be acquitted except unless you die or it turns out you might be the wrong person. So effectively, a prosecution means that you'll be convicted. But I've seen the Australian officials examine cases and say, well, what about this case? Can you do anything else to fight your case? And asking somebody to provide that sort of genuine court documents from China, which don't exist because the process is not the same. Because the process is the police officers interview you, and effectively, unless they are bribed enough money or unless you have powerful influence, you'll be prosecuted and you'll be convicted and you'll be sentenced. And so China more than anybody else has gone through a huge attack on individuals. Some are criminals. There are some within that who are accused of genuine criminal activity, but they've also gone and attack against business. They've gone against anybody who has what they consider to be westernized views, and that tends to be people who've made money, so successful entrepreneurs, successful bankers, successful business people who often live outside China but have family in China, and they are seen as ideologically opposed to the current regime, and that's, I mean, it's a fairly recent change, and it's become almost paranoid in that the individuals who are um, who have Western values have been targeted. High profile people have been disappeared. You know, you see Jack Ma, it was only a few years ago where he disappeared, the actress Fan Bingbang. The former president of Interpol, Meng Hongwei, in 2016 was kidnapped by the Chinese, flown to Beijing, disappeared. Nobody knew where he was. And then he reappeared, pleaded guilty to corruption charges, and nobody's seen him since, as far as I can work out. And so it's a terrifying prospect to be on the end of a Chinese red notice, because they use the red notice to do as much damage as they can, and don't really ever intend to follow that up with either an extradition request, often, or any other action. In Europe, there's been a few developments. There's been a lot of discharges in relation to China. There was a European Court of Human Rights case called Liu in Poland, Liu in Poland, which said that Chinese prisons are non-compliant with human rights, high risk of torture, and that's before you even get into people who are of the wrong ethnicity, according to the Chinese, or Uyghurs, etc., or any sort of political activists who are targeted, tortured, and often disappeared, which is saying that they are often killed and organ harvested, not to put too fine a point on it in relation to certain religions. So it's pretty horrific what happens, and yet governments still look at a Chinese red notice, often sometimes as a Russian red notice, and Interpol doesn't say, well, it's just, it's a red notice, we should believe them, and that's can cause a real problem in immigration proceedings.
If I could also mention, just to add on to that last uh, information that you had shared with us, Ben, with relation to Section 501 in Australia, there is the inference that there is an understanding that some countries may use Interpol red notices as a way to punish certain individuals, even though the red notice doesn't have any foundation on it. And that comes from Section 501, subsection 6H, which actually mentions that a person won't pass the character test for the grant of a visa if an Interpol notice in relation to the person is in force, and it is reasonable to infer from that notice that the person would present a risk to the Australian community. So I think there is an inference that the department and the minister understand that the notice itself has to infer that the person would be a risk to the Australian community, even though someone has been issued a red notice. It isn't always on face value a reason for that person to have their visa cancelled or refused. So I think that's also interesting as well.
I mean,
It
that's very
is,
interesting.
but the problem is, if you feel that this red notice has been politically motivated, a couple of years ago we did act for a Chinese citizen who challenged, she had certain property which he inherited, and then some local mayor wanted to take that property over, and he challenged it in the courts. And then, as a result of that, he got this red notice, which caused him a character problem on his visa. And at the end of the day, we had to get like a international risk assessment done in relation to the how genuine were these charges, and were they just basically um, brought because of the situation. And it's all very well for the legislation to have that section in it, but you've got to have some backup or some evidence to
Mhm.
support that. Otherwise, if you have the red notice just alone, it's very difficult. And also now with the new direction 110, where community safety, expectations, I mean, the whole idea of the concept around national interest and the High Court definition of is going to come into play. And ultimately, you're going to have delegates of the minister making decisions on these very complex matters.
And I think it's also, I mean, there's a sort of rule Interpol and extradition proceedings is that as soon as you start looking at the facts of a case and trying to disprove them or prove them, you end up in a very difficult situation because it's almost impossible, because you're trying to prove your innocence. You're trying to say, well, there's no foundation whatsoever for these criminal offences. And my experience of a lot of Chinese cases is they, as Anne says, is they start as a civil dispute. And because everybody is connected to the party, if you then potentially win a civil dispute, then somebody will take a criminal complaint out against you, and then you get a red notice, and then you're in real trouble. But if you're going to fabricate a case, or you're going to bring a case on grounds of religion, or I mean, all the Uyghurs, who are a represented number of them, are requested on terrorist charges. So on the face of the red notice, they are requested for terrorism, sedition in China. So on the face of the red notice, they would not qualify potentially in Australia, because terrorists obviously present a threat to national security. But we know from research and a significant amount of lobbying and discussion in the human rights community that the Uyghurs are deliberately persecuted and these charges are fabricated. But it's impossible to disprove the facts as stated in the red notice, or facts that are stated in an extradition request, because China are always going to return with more fabricated evidence. In some respects, in those, I mean, particularly in the highly politically sensitive cases, it's you try and show that this is part of a pattern, a part of an attack on particular individuals, particular groups of individuals by the Chinese, rather than trying to get into the minutiae of whether in fact it's a genuine criminal prosecution, or, because in my experience it's very, very difficult to show that to any degree of likelihood.
I think, do we have some questions? I see some questions were coming in on the chat.
Hi, Anne. Yes, we've just had a question through. If you would like me to ask that, and just to say thank you very much, everybody sending questions in. Please do keep those coming in. We have a bit of time. There's a fabulous time to get your question answered by Anne and Ben. How would Australian immigration view red notice from China, and how would the authority view if the red notice was deleted by Interpol CCF? Is this going to be a negative or positive for refugee visa application?
Well, I think it's very contentious with a refugee application. And is the person asking the question suggesting if it was withdrawn, would that help the situation?
I think there's a step. I should just quickly explain. I think what the question is saying is the thing I haven't explained is that you can remove a red notice. So you can make an application, make lots of them, to Interpol, to the Commission for the Control of Files, who are a semi-independent body composed of human rights lawyers who examine the submissions and decide whether or not the information obtained by Interpol or held by Interpol is either politically motivated, potentially in breach of human rights, or breaches one of the other codes, for instance, not specific about what's happened. And in relation to the CCF, the problem with the CCF is it's taking over a year to remove a red notice. And also, for instance, in relation to Russia, the CCF seem to be very minded to Russia and don't seem to be removing that many of the Russian notices. They seem to be thinking that they tend to be genuine prosecutions. And so you get this issue, and you can apply to the CCF, to Interpol, to remove the red notice, but it's going to take, I mean, it's a year from submission at the moment. And you can't it's not that straightforward to remove them. And in the interim, you've got to work out how, whether you're going to get your visa or whether you're going to be able to claim asylum in the interim.
And what do you do in the process if you're facing a notice of intention to cancel or something like that, and you ask the case officer not to make a decision until we've had a decision on the red notice? That's problematic as well. And also with the national interest, you just don't know the type of attitude that will be taken. There's an acknowledgement that it could be politically motivated, but if the case officer draws a different conclusion on the facts, you could well have a refusal. on character grounds?
I mean, my experience of dealing with those sort of issues is a removal by the CCF saying it's politically motivated is obviously a strong case that the red notice was fabricated. But getting that decision is pretty hard work because the CCF would rather discharge something on a technical ground, on a non-compliance ground, rather than go through all the rigmarole of deciding, reading expert reports and making a decision. Plus, everything at the CCF is done in writing. I mean, there's a 3 or 4 days every 3 months at which they get to consider the cases, and there's currently, I think, around 650 a year people who apply to have the red notice removed, which is a tiny fraction of the number because most people don't know about them. And so I think if you have a red notice removed, it seriously helps your case. But ultimately, getting it removed on a political ground is pretty hard work. And in fact, you're better, in my experience, trying to explain to domestic authorities who will have more time, will have an appellant process potentially, or a court process, why something's politically motivated when you can actually call evidence, provide better expert reports, provide a more background to what's going on, whereas the CCF has quite a limited function. And so whilst a politically motivated removal is very advantageous, getting one is not actually as easy as everybody thinks it might be.
Very bureaucratic process.
Yeah, I'm not quite sure whether that quite answers the question, but it's my best stab at it.
Any more questions there, Dan?
No questions through so far, but we do have a bit more time
I
left.
thought we could just briefly talk about the new direction and where we think that's taking character cases in Australia. Diane, what's your opinion of the new direction 110 and the movement for community safety as a very high priority and best interests of the children, although still a primary consideration, is not the highest of the concerns?
Yes. So I think that the current direction 110 is one that I think a lot of people are confused on, only because of the only just recent Direction 99 that was introduced last year, with the government's prioritization on the mitigating factors for people who are affected by character concerns and criminal convictions. But I also think if we take a further step back and we look at the character paradigm that we have in Australia, and the historic national interest that you had touched on previously, Anne, I think that the national interest and the powers that are given to the minister also ties into the introduction of Direction 110, and that is ultimately that the minister is given quite a lot of discretion. If we want to talk in a literal sense, it is limitless in a sense where he can bring in a direction that goes into a different direction than the previous. In terms of national interest, I think that it encapsulates a legal tension almost between the government's duty to protect the Australian community and also the ethical obligations that are required to be given to visa applicants. And I think Direction 110, while some might think that it strickens the way in which we welcome people who have character concerns in Australia, which of course is welcomed if it is utilised, in a way where we are protecting the Australian community. But I think it might result in a lot of decisions that are made that don't exactly give due diligence to people who have overcome their criminality, which I know that for myself and Anne and the firm, we deal with a lot of character cases where the person has had a previous conviction that has been quite a long time. So they've, the risk of recidivism is low. So I think the only way really to see the direction 110 play out in a legal sense is to see how the minister's decision making forward and the precedents that it will bring forward see how that pans out.
Well, yeah, I agree, Diane. And, you could basically, if the minister wishes to exercise his personal power, I think it's under Section 503, um, you could have someone without a substantial criminal record, but still could be a character concern and could also attract the national interest. And that is a concern in itself because there's no administrative appeal rights. You have to go straight to the federal court. So I think we're in for an interesting journey in Australia. And unfortunately, this particular direction was brought into place because of political situations. And the Prime Minister said, well, we'll just revise the direction then. And we had a direction 90, we had a direction 99, and now we've got a direction 110. So that's the situation. I did notice there was another question that came up, Dan.
Yes, you're quite right, Anne. What scope is there to appeal or review a case officer's assessment on character or the minister's decision?
Well, it really depends on whether it's a personal decision of the minister. If it's a personal decision of the minister, we don't have administrative law rights to review it to a tribunal. If it is not, if it is just a decision on character, we do have review rights to the tribunal. But if it's a personal decision of the minister, we've got to go to the federal court, and there are quite a few hoops to get over that way. It's better to have a decision where you do have natural justice and administrative law review rights.
Great, thanks, Anne. And I will say, if you do have a question, please do send it through. As you see, we'll be able to get it answered today. Anne, I'll hand back to you. Thank you.
I thought it might be worth just briefly giving some ideas about how you might go about attacking red notices. It very much depends on the jurisdiction you're dealing with, but for Chinese, Russian, Bahraini, the sort of the red notices which come from states with no rule of law, it's often useful to obtain either a country specialist expert report or an Interpol specialist expert report, essentially going through the risk of human rights in a particular country, but also the history of abuse of Interpol by a particular country. So, for instance, Bahrain, I've got a series of Bahraini clients who've represented, and I've given expert evidence in relation to Bahrain's misuse of Interpol. I mean, it's quite widely known, but there are specialists in Turkey, and I've done matters in relation to China and Russia. But also, you might want a country specialist to explain, for instance, in Russia, how corporate raiding works and how that can be politically motivated in order to either convince Interpol or convince domestic decision makers that, in fact, the allegations behind the red notice are politically motivated or will result in some form of torture or persecution. There's a question.
Okay, yes, I just saw that, but it was like it was half finished. Was the question, if you get a red notice withdrawn, does that solve the problem? What was the question about, Dan?
Yeah, and we can ask. Sorry, Ben.
No, go for it.
Yeah, we can ask the questioner if they want to send in or clarify anything that they sent. But the question that they sent over was, does deletion of red notice from Interpol CCF directly explain the applicant's character in Australia? Surely deletion was based on Article 2 and Article 3 of the Interpol Constitution.
Well, I think perhaps Ben should address that first from the deletion of the red notice, and then I can talk about the Australian context.
So I think I sort of alluded to it. I mean, we talk quite a lot about getting things. So 2 and 3 of the Interpol Constitution are the provisions which say shouldn't be politically motivated and should be in compliance with human rights. But ultimately, Interpol don't particularly like using those sections, and often will discharge on other more technical grounds. So often, failure to provide proper details in certain aspects, and so it's not always a deletion on Article 2 or Article 3 can be fairly clear indication that the particular prosecution was either politically motivated or persecution. But it isn't always evidence, and you won't always get a really clear decision from Interpol about the reasons. They may just say it's deleted because of those reasons, and then you sort of have to try and extrapolate what happens.
From the Australian perspective, we would have to explain a little bit more about it. The fact that it was deleted or it was on technical grounds, we would still need to explain that context, because if there was a concern that it wasn't politically motivated and there was a concern in the national interest, then of course we're still going to have this problem with Section 501. So we're going to have some form of explanation. It's like a bad credit rating that's removed or something like that. Or, you know, the way Australian immigration works out is it's not like a criminal law sort of situation where you're guilty or not guilty or you get mitigation. The character section is more equity based. They want to know the story, they want full transparency, and then they make a decision. Even say, for example, you get a non-conviction, it's still disclosable under 501, and you've got to explain the circumstances of the offence. So that explanation, you just can't say, oh, well, I don't know whether it's correct to say then that a red notice has been deleted, but say the process has gone through and there was a review by the Interpol. That just itself on its own would not be, in my opinion, enough. What do you think, Diane, under the Australian context?
Yeah, I completely agree. I think your you mentioning the national interest, I think, is crucial in this context, because I think the way in which Section 501 can be applied and the way that the minister's discretions can be applied, even if under Section 501, someone, for example, who has had a red notice that has then been deleted, even if they don't have the red notice currently, and even if they don't have what is known as a exhaustive criminal record under Section 501, the minister still has that discretion to refuse or to cancel a visa. And I think the notion of national interest in terms of the minister's discretions, like Anne has touched on, it raises profound ethical questions about the balance between the public security, which of course the minister must keep in mind, and also the rights and the dignity of individuals who, like someone who has had a red notice removed, may have been victimised by unjust systems or unjust governments who have placed that initial Interpol red notice. So I think, even touching on what Ben said, there are instances, maybe than more often than not, where individuals from certain countries do get red notices placed on their record for solely political purposes. So I think in the context of Australia, it would be on a case by case basis, directly pertaining to that question, on whether the person's visa would be affected by that red notice. But, touching back to what Anne said, it would definitely have to be addressed nonetheless.
I think it's also worth saying that when I sort of say political, and that's the definition of Interpol's constitution, but political can be political with a small p. It can be, as we said, a civil dispute with somebody in power, which then turns into a criminal complaint, and which might be considered a political belief under the Refugee Convention, but wouldn't necessarily qualify as a political offence exception. And so there's a grey area which Interpol haven't necessarily qualified entirely as to how they approach political motivation, whether they take them, how broad is their definition of political motivation, essentially. And it's not always clear from their decisions as to how broadly they take it, and it's really very much case by case basis.
It's not an
Brilliant.
exact science. It's as Ben rightly says. I mean, you have to treat every matter on a case by case basis. And certainly our experience with the Chinese, it was a civil dispute, which then resulted in a red notice.
Excellent. Brilliant. Just looking at the time, we may need to wrap up there. But what I do want to do before we leave, Anne, Ben and Diane, if you have any closing comments, please do share those with us in the audience.
Well, I think we're in for a very interesting ride with the new Direction 110. I feel the firm's up for the challenge, and we will be dealing with each case on a case by case basis. And I think it will be a new route to go down, and it'll be interesting to see what outcomes. But what I can say, if you have got an immigration character issue, I would strongly suggest you certainly bring in an accomplished immigration lawyer, because now with the new direction and the political climate in Australia at the moment, we're coming into perhaps an election next year. Migration and character are big concerns, energy are big concerns, and it always makes life more interesting and more difficult where political considerations are coming into the mix. You're about to get a new election very soon too, aren't you, Ben?
Yes, and we've also just you're getting your countryman back. Mr. Assange has left. I think he's on his way home.
Yes, he is on his way home. But I think there's a GoFundMe account to get $520,000 for the charter flight for the plane or something. He has a debt now for that charter flight. But it's certainly been a very long time in coming, and I know a lot of advocates have worked very strongly. I know it's a controversial decision. There are pro and against, but at least it's a resolution to an outcome.
Yeah, exactly.
Excellent. Brilliant. Well, thank you very much, Anne, Ben, Diane, for your time, for your insights, a fascinating discussion. As always, with Immigration Solution Lawyers, we hope we can have you back again soon. And thank you very much to our audience for your questions. We really appreciate your time. All I can say is thank you very much. Have a lovely rest of your day. Goodbye.
Thank you.
Thank you.